Good afternoon. On behalf of Terra Firma Chambers, I would like to welcome you to the latest in our series of webinars. We started a few weeks ago with our spring series with a short double bill of webinars on the community right to buy and the common good property and community asset transfer. Those presentations can be found on our YouTube channel. But today we move to another of the areas in which members of our chambers have a special interest and expertise: immigration and asylum law, where two of our advocates will be presenting an update on recent developments in two particular areas. Our first speaker will be Stephen Winter. Stephen has been with Terra Firma Chambers since he called to the bar in 2011, and his main focus is on immigration and asylum matters. He's ranked band 1 in immigration law by Chambers. He's written and researched on some of the procedural questions that arise in immigration tribunals and in judicial review applications to the Court of Session. And some of those procedural questions will be the subject of the presentation today, which, as you will see, will focus on recent case law concerning issues of procedural fairness. Our second speaker is Farima Barani. Farima joined Terra Firma Chambers in 2015, when she called to the bar, and immigration and asylum has been one of the focuses of her work since then. And her topic today is a widely publicized and controversial case concerning Shamima Begum. That subject, of course, was deprivation of British citizenship, but it's got many potential implications which go beyond that, as you will hear from Farima. Before I hand over to Stephen, just a couple of basic housekeeping matters. As I'm sure many of you will know from previous webinars, this is in webinar format, so those attending will not be able to speak in the webinar, but there'll be plenty of opportunity for questions and answers. If you've got a question to our speakers, please put that in the question and answer box on your laptop or tablet, and we'll try and take as many as we can. And after the webinar, you will be sent an email with the slides and also a link to our YouTube channel as well, so you can keep the information for future use and reference as well. So with those opening remarks, I'd like to hand over to Stephen Winter.
Well, thanks, Mark, for those introductory remarks. As you have indicated, my talk's really going to focus on procedural fairness. When I was asked to do this talk, I was going to sort of do a general case law update, but saw there was a common theme running through some of the cases concerning procedural fairness, and as the slide indicates, the main one being the Supreme Court case of Pathan, which was decided last year. And the citation is there for anyone who wants to look it up while I'm giving the chat and going through various paragraphs of that case. So the Supreme Court case of Pathan, as the slide makes clear, the point was a fairly basic one, that the claimant had applied for leave to remain under Tier 2, and that was refused because of the revocation of his employer's sponsorship license. The claimant was only made aware of that when his leave to remain was refused. So the question really was whether the failure to notify the claimant about his revocation of his sponsor's license was procedurally unfair. And the majority view, 4-1, was that it was procedurally unfair. And I just want to explore some of the key paragraphs as to why that view was taken. In terms of the majority view, what the Home Office tried to argue was that this wasn't really a question of procedural unfairness, but rather it was a question of substantive fairness, which isn't really a separate head of claim for judicial review. However, Lady Arden, along with Lord Kerr and Lady Black, disagreed with that view. And effectively, what they said was that the ground was correctly categorised as procedural unfairness. And if there was a substantive benefit, such as the claimant being able to get leave to remain, then so be it. But the correct categorisation of the ground was procedural fairness. And as the slide says there, paragraph 32, which is part of Lady Arden's speech, she says there that it seems to me that there's undeniably also an element of substance in Mr. Pathlin's challenge. By the way I see it is as a consequence of his argument about procedural fairness and not vice versa. And Lord Kerr and Lady Black also concurred with that view at paragraph 137. Just scroll down to find the relevant paragraph. And at paragraph 137, Lord Kerr turns to the debate as to whether the duty to act fairly by providing the information promptly in terms of the revocation of the sponsor's licence is procedural or substantive. They say that they reject the Home Office's position. They go on to say that a distinction must be drawn between the duty to act in a procedurally fair way and the use which the beneficiary of the discharge of that duty will avail of it. And they go on to say that it's generally accepted that the duty to give a person affected by an adverse decision the opportunity to make representations is procedural, and if by making those representations the affected person secures a change of mind by the decision maker, the favourable result may be regarded as a substantive benefit. And they reiterate that at paragraph 138, where they say that the procedural duty to act fairly by giving the opportunity to make representations exists whether or not the opportunity is availed of. Likewise, in the case of the duty to provide relevant information promptly, the late Lord Kerr and Lady Black say in both cases, agency responsible acts in contemplation that the person affected will take a particular course to avoid the impact of the decision, and that it is fair that he or she should have the chance to do so. This is what underpins the duty. If the opportunity is taken and a different outcome is obtained, that can be regarded as a substantive benefit, but it doesn't make the duty to inform or to allow representations to be made any less of a procedural duty. And at paragraph 139, they simply reiterate that the duty to act fairly involves allowing the opportunity to influence the result, and their opinion is that duty is to be regarded as a procedural duty. They go on to say that paragraph 140, that once the opportunity to make submissions or the chance to take different steps has been provided, the procedural duty has been fulfilled. To deny the chance to make submissions or to fail to inform promptly involves breach of that duty. So that was how they distinguished the procedural and substantive fairness point. As the slide goes on to say, Lady Arden does point to the values of procedural fairness at paragraphs 48 to 52 of the decision. And in those paragraphs, she takes the values from what Lord Bede said in a case of Osborne, which was all to do with parole. And I'll just scroll up to get those. And there were three values that were identified. Paragraph 49 of Pathan, Lady Arden says that the first value was that it satisfied a person's intuitive expectations of what a just process involved. She then cites from what Lord Reid says in the case of Osborne, where it said that the first was described by Lord Hoffman as the avoidance of the sense of injustice which the person who is the subject of the decision will otherwise feel. I would prefer to consider first the reason for that sense of injustice, namely that justice is intuitively understood to require a procedure which pays due respect to persons whose rights are significantly affected by decisions taken in the exercise of administrative or judicial functions. The second value was that procedural fairness promotes congruence between decision-making and the law. And the quote from Lord Reid is that the second value is the rule of law. Procedural requirements that decision makers should listen to persons who have something relevant to say promote congruence between the actions of decision makers and the law which should govern their actions. And then the third value in procedural fairness was cost. Lady Arden says, well, it may appear that the cost of providing a person with an oral hearing, not in point and pathon, increases the cost of decision making. That may not be the case if the decision reached is a fairer one. And then quoting from Lord Reid's decision, where Lord Reid said that the easy assumption that it is cheaper to decide matters without having to spend time listening to what the persons affected may have to say begs a number of questions. In the context of parole, where the cost of an inaccurate risk assessment may be high, procedures which involve an immediate cost but contribute to better decision making are in reality less costly than they may appear. And Lady Arden concludes that procedural fairness is thus an important matter. It makes the law more just and at the same time improves the standards with which decision makers are expected to comply in the 21st century. And that paragraph 53, she just recognises also that substantive unfairness is not in itself ahead of judicial review. Lady Arden then goes on at paragraph 55 to ask various questions about what fairness requires. And she quotes from the well-known case of ex parte Doody, where Lord Mustill outlined 6 points. Firstly, where an Act of Parliament confers an administrative power, there is a presumption that it will be exercised in a manner which is fair in all the circumstances. Secondly, the standards of fairness are not immutable. They may change with the passage of time, both in the general and their application to decisions of a particular time. Thirdly, the principles of fairness are not to be applied by rote identically in every situation. What fairness demands is dependent on the context of the decision, and this is to be taken into account in all its aspects. Fourthly, an essential feature of the context is the statute which creates a discretion as regards both its language and the shape of the legal and administrative system within which the decision is taken. Fifthly, fairness will very often require that a person who may be adversely affected by the decision will have an opportunity to make representations either before the decision is taken or after or both. And sixthly, since the person affected usually cannot make worthwhile representations without knowing what factors may weigh against his interests, fairness will very often require that he is informed of the gist of the case which he has to answer. Lady Arden goes on at paragraph 56, in the present case, the procedural fairness aims to achieve is a person who, like Mr. Pathan, is applying for further leave in order to continue working for a sponsor, should have notice of the communication to the sponsor of the termination of the Home Office that the sponsor's licence is revoked. And where the Secretary of State has initiated the process for revocation, and the revocation is the cause of the invalidation of his application, Lady Arden's view was it's right that Mr. Pathan should have that information in order to avert or mitigate the potential fatal blow to his application. Now, that links into the possible advantages identified by Lord Kerr initially at paragraph 100, but those advantages run through Lord Kerr and Lady Black's opinion. But at paragraph 100 of that case, the court goes on to say that if Mr. Pathan had been given notice of the revocation of his sponsor's licence, a number of options would have been open to him. Firstly, he could have sought to vary his leave application. Secondly, he could have made an application to vary the terms on which he was entitled to remain in terms of human rights grounds. Thirdly, he could have made practical plans to remove himself and his family to India, thereby avoiding the consequence of becoming an overstayer. Or fourthly, he could have decided to take no steps until formally notified by the Secretary of State. And the paragraphs cited in the slide outline those reasons right down to paragraphs 113 to 114. And Lord Kerr then does contrast the consequences of being an oversteer, to which he had already referenced, at paragraph 115. And he acknowledges that there are two types of effect of becoming an oversteer, an immediate effect and a long-term one. In terms of the immediate effect, he says that if one is knowingly an oversteer, one automatically commits an offence under section 24(1)(b) of the Immigration Act 1971, thus becoming liable to imprisonment for a term of up to 6 months or a fine. And being illegal also prohibits employment and also other issues. At paragraph 116, he outlines the long-term consequences, particularly in terms of the prohibition in returning to the UK within a certain period of time, and it sets out a table at paragraph 115, which gives the length of a ban from 12 months to 10 years. So that was the background before Lord Kerr and Lady Black go on to the issue of pointlessness, which is identified at paragraphs 118. And at paragraph 118, what they ask is that when an administrative body is contemplating a decision which will adversely affect an individual, does the duty to act in a procedurally fair way require the body to inform the individual, even though any representations that he or she might make will not affect the outcome? Or to put it in other words, is the duty to act fairly by giving notice of an impending adverse decision dependent on the existence of the possibility of submissions by the person affected, bringing about a change of mind by the decision maker? And at paragraph 121, they identify that pointlessness does have two dimensions. The first is that there's no possibility of bringing about a change of mind on the part of the authority on the terms of the decision that has been made. So, for instance, in the present case, Mr. Pathan's application, so long as it was based on a sponsorship certificate issued by a company which had ceased to have authority to issue one, could not succeed in any circumstances. The second dimension, though, is different. It involves an examination of whether, on becoming aware of the decision, there was simply nothing that the affected person could do to achieve the same. In other words, there was no other avenue which he or she could explore to avoid the impact of the adverse decision. And at paragraph 122, the court recognised that they are concerned with this second dimension. And as already noted, and what Lord Kerr and Lady Black said at paragraph 103, that it couldn't be said that there wasn't an avenue to be pursued had Mr. Pathan been notified of the decision to revoke the sponsorship licence. And that's really reiterated all the way down to paragraph 131 to 135. They recognise at 131 that had Mr. Pathan been made aware of the revocation of his sponsor's licence, that he could have tried to obtain another sponsorship licence and to make a new application. And they ask at 132, what was the fair thing to do procedurally? In our judgment, it was to tell Mr. Pathan as soon as reasonably possible after the cancellation of his sponsorship licence that this had happened, and he would then have known that his application in its current form was bound to fail. That was really the key aspects of the Pathan case, and there have been a couple of cases decided since then. The first case in the slide there is the case of Taj. Now, Taj related to application as to whether or not leave to remain should be given as an entrepreneur to the applicant. And it really concerned whether or not the business was genuine or not. In terms of the approach, at paragraph 2 of Taj, the case of Dudi is referred to, and then at paragraph 3, the case of Pathan is referred to as well, and the issue about the business is identified at paragraph 4. And at paragraphs 49 to 50, there is a useful summary of Pathan, and they really reiterate the points that I've already taken you to. At paragraph 49, They refer to the facts of Pathan, and at paragraph 50 they outline some of the main points that the duty principles of fairness apply to the points-based system, but their application is fact and context specific. At point 2, they outline that the principle of procedural fairness supports important public interest values, and those identified by Lady Arden. They also refer to the pointlessness test. They say that because of the broader public interest reasons for the principle of procedural fairness, the courts do not undertake any detailed analysis of whether, had the breach not occurred, it would have made any difference. In Pathan, the majority were unimpressed by the respondents' arguments to grant relief would be pointless. The majority considered that the breach did deprive Mr. Pathan of at least the opportunity to better his position. They also identify a couple of other things from Pathan, that procedural fairness isn't standalone. So a challenge based upon procedural fairness doesn't have to be linked to a traditional judicial review challenge. And they also refer to the cost point, which was identified from one of the values that Lord Reid spoke about. In terms of distinguishing Pathan, in this case, what the court effectively founded upon at paragraph 54 was that in Pathan, Pathan couldn't really be blamed at all for what happened, because he was unaware that his sponsorship license had been revoked. And at paragraph 54, the court identify that. They say that it's clear from the judgments that key determinants of fairness will focus upon A, who has access to the information needed to support an application for leave to remain, and B, who has control over that information. And they go on to say that unlike in Pathan, in Taj, the appellant had both access to and control over every fact relevant to the success or failure of his application. The scope of the evidence to be submitted is narrow and exclusively in the possession and knowledge, and therefore under the control of the applicant, not the state. They also founded upon at paragraph 55 their view that the points-based system is open and transparent, and the appellant knew full well the evidence that needed to be provided, and that the burden, therefore, at paragraph 56 of that case, the burden of providing the information lay with the applicant as it does under the rules. And they go on to say that if a series of inaccurate or incomplete pieces of information are tendered, responsibility fairly lies at the door of the applicant. And they then really hone in on those at paragraph 75 to 77, and take the view that there was no need to tell the applicant about their concerns, and particularly in terms of paragraph 77, that they identified that the proof needed will be largely documentary and the particulars independently verifiable, and therefore the veracity of an applicant's account should not lie at the heart of the process. They state that an applicant should be able to establish a case for leave to remain using, for example, emails with clients, invoices, business plans, etc. So it was on that basis that Pathan was distinguished. A similar case is Topadar, which was actually decided prior to Taj, but both cases really tie in. And in this case, Topadar concerned the Secretary of State's failure to notify the claimant that further information had been requested from the claimant's sponsor, his employer, and the sponsor hadn't responded. Now, the court did hold that there was no procedural unfairness in relation to that. And again, they very much relied on the same reasons as identified in Taj and as summarised on the slide there. But at paragraph 53, they again relied on the fact that, in their view, the PBS system was open and transparent. Applicants knew the specific evidence that they needed to be submitted, and the requirements of procedural fairness have to be understood in that context. And at paragraph 54, they noted that part of the rules was that the Home Office could request further information from the employer, and at paragraph 55 of that case, there was nothing procedurally unfair in the respondent asking the sponsor for additional information and evidence. And ultimately, it distinguishes Pathan again on the same basis of Taj, that in Pathan he knew nothing about it, whereas here this was a case where the sponsor was entitled to give further information if requested. And at paragraph 60 and 61, the court draw that distinction. At paragraph 61, they say that here the decision-making process, where in accordance with the relevant rules, the sponsor is required to provide evidence of certain matters to enable the respondent to assess whether a job vacancy was a genuine vacancy. The rules provided that if the information was not provided, the application for leave to remain might be refused. The sponsor was asked to provide the information, it did not do so, and therefore the Home Office couldn't therefore be satisfied that the sponsor did require an accounts manager. The last case, just very briefly before turning to Farima's talk, is the case of Wahid, which is on the slide there. This was a case where they did find that the principles of Pathan did apply. In particular, this was a challenge, an appeal against a refusal to allow a judicial review against the decision of the entry clearance officer. So it was only a permission hearing, but at paragraph 32 of that decision, the court did distinguish this case on the basis that the appellant's own credibility was in doubt. It wasn't mitigated by independent or verifiable documentary evidence. And at paragraph 32, the court said that I am persuaded that it is arguable that where an ECO harbours suspicion of dishonesty, procedural fairness requires the applicant to have the opportunity to respond, and in particular where a finding of dishonesty can have serious repercussions. So on that note, I'll finish. I appreciate that was a fairly brief and succinct overview, but hopefully you've taken away the key points, and I'll now hand over to Farima.
Thank you, Stephen. Apologies, after all this time, I'm still having trouble unmuting myself. I don't propose to go too deeply into the background of this case, as it's quite well known. I will briefly touch on the appeal history before turning to consider the Supreme Court's judgment. Now, Ms. Begum travelled to Syria to join ISIL when she was just 15 years old. She was 19 when she was interviewed by journalists who found her in the Al-Hol camp in Syria. Following the interview being published in the Times, the Home Secretary wrote to her, giving her notice that he intended to deprive her of her British citizenship. Ms. Begum sought to appeal the decision and applied for leave to enter outside the immigration rules to take part in her appeal in the UK. The Secretary of State refused leave to enter, and Ms. Begum appealed her decision to the Special Immigrations Appeal Commission, or SIAC. She also raised an application for judicial review of the refusal to enter, to grant leave to enter in the administrative court. SIAC, in a nutshell, held that as Ms. Begum was 19 years old when the deprivation order was made, her Bangladeshi citizenship, which it held that she held through descent and as of right, was not affected, and so the deprivation order had not rendered her stateless. Had she been 21 or older at the time of the deprivation order, however, she would have been rendered stateless, and it's likely that the deprivation appeal would have been allowed. So Ms. Begum has been unable to appeal SIAC's decision in the deprivation appeal as there hasn't been a final determination. However, she has appealed against the rest of SEAC's determinations. Now, the Court of Appeal in the Divisional Court allowed Ms. Begum's appeal against the dismissal of the leave to enter appeal and against the dismissal of the leave to enter judicial review. The court ordered the Secretary of State to allow Ms. Begum leave to enter the UK and ordered it to provide the necessary travel documents. The court allowed her application for judicial review of SEAC's decision that the Secretary of State did not breach his extraterritorial human rights policy and remitted the issue to SEAC for redetermination. However, the court dismissed Ms. Begum's application for judicial review of SEAC's decision that her appeal should not be automatically allowed if leave to enter the UK was refused. The Home Secretary appealed against all of these decisions, but the final one cross-appealed in relation to the final decision. So turning first to the cross-appeal in the Supreme Court, in her cross-appeal, counsel for Ms. Begum argued that the power to deprive someone of their citizenship could only be exercised in compliance with the principles of natural justice. So where there can't be a fair and effective appeal, the decision is inconsistent with natural justice. So what did the Supreme Court think of this? Well, the court rejected the argument as being fallacious. The court, quoting Eleanor Roosevelt, a champion of civil liberties, stated that justice cannot be for one side alone, but must be for both. Accordingly, the court held that it would be unjust to allow the respondent, unjust to the respondent and to the public interest if an appeal were allowed simply because the appellant was unable to effectively represent her appeal. While the decision may have serious consequences for the appellant, setting aside the decision may have serious consequences for the public interest. The court thought it would be irresponsible to allow the appeal without any regard to the interests of national security, which prompted the decision in question. Accordingly, Ms. Begum's cross-appeal was dismissed. Moving on to consider the appeal against the leave to enter decision and the judicial review application against the leave to enter decision. In considering the leave to enter appeal and the leave to enter judicial review, the Court of Appeal compared the risk to national security posed by Ms. Begum with that posed by U2, an individual in another case that had been deemed a threat and refused entry. And the Court of Appeal decided that Ms. Begum posed a lesser threat which could be managed. The Court of Appeal decided that any risk posed by Ms. Begum could be addressed by her being arrested and charged on her arrival in the UK, or by her being made the subject of a measure under the Terrorism Prevention and Investigation Measures Act 2011. So this aspect of Ms. Begum's case had been based solely on common law principles rather than principles arising under the Human Rights Act 1998. So how did the Supreme Court view this aspect of the Court of Appeal's judgment? The Supreme Court was highly critical of the Court of Appeal's judgment in this respect. The court noted that counsel for Ms. Begum had pointed out that a leave to enter appeal could only be made on the basis that the leave to enter decision was unlawful under Section 6 of the Human Rights Act 1998. Accordingly, counsel for Ms. Begum had invited the court to allow the appeal from SEAC's refusal to grant her judicial review of the leave to enter decision, rather than from SEAC's refusal to allow the leave to enter appeal. The Court of Appeal nonetheless wrongly allowed the leave to enter appeal on the basis of common law principles. Accordingly, the Secretary of State's appeal against the Court of Appeal's decision in the leave to enter appeal was allowed by the Supreme Court. It had no basis in law, and it's unclear why the appeal was put forward on those grounds. The leave to enter judicial review, however, was not limited to Human Rights Act grounds, and so the Supreme Court continued its consideration of this aspect of the case, turning to the matter of national security. The Supreme Court was also critical of the Court of Appeal's consideration of national security matters. The Court of Appeal, according to the Supreme Court, lacked jurisdiction to consider national security, as neither SEAC nor the Administrative Court had heard evidence on the substantive case on national security, and so there had been no relevant findings. The Court of Appeal wasn't factually able to make a national security comparison. It wasn't open to the court to simply conclude that anyone posing a lesser risk than U2 could be safely managed within the UK. There was no evidence before the Court of Appeal from the police, Crown Prosecution Service, or the Director of Public Prosecutions as to whether it would be possible or appropriate for Ms. Begum to be arrested and charged with an offence on her return, or whether, even in such an event, she would be remanded in custody. Accordingly, the Court of Appeal, according to the Supreme Court, wasn't in a position to reach a view on these points. In relation to measures under the Terrorism Prevention and Investigations Measures Act, again, there had been no evidence or submissions before the Court of Appeal as to whether such a measure could be imposed or how effective it might be. The Court of Appeal had also overlooked the institutional and constitutional limits on its competence to decide questions of national security. Finally, the Court of Appeal had found that the only way Ms. Begum could have a fair and effective appeal is if she were permitted to enter the UK. And so fairness and justice outweighed the national security concerns, leading to the conclusion that the leave to enter appeal and judicial review should be allowed. Again, the Supreme Court disagreed. It held that the view that the right to an effective appeal is a trump card was mistaken. Even if the Court of Appeal had been attempting to balance the public interest in Ms. Begum's ability to pursue her appeal against the public interest in minimising the risk of terrorism, it couldn't have done so in proceedings where the Secretary of State's decision had not been challenged on that basis. And even if it had, the Court of Appeal, according to the Supreme Court, would have been confined to reviewing the reasonableness of the Secretary of State's assessment. Accordingly, the Secretary of State's appeal against the decision to allow the leave to enter judicial review was also allowed. So next, we turn to consider the Supreme Court's consideration of the final issue, the Divisional Court's decision to allow Ms. Begum's application for judicial review of SEAC's decision in relation to the Secretary of State's extraterritorial human rights policy. In terms of the policy, the Secretary of State had asked himself whether it would be a direct and foreseeable consequence of the deprivation order that Ms. Begum would be exposed to a real risk of ill treatment breaching Articles 2 or 3 of the ECHR if those provisions were applicable. Now, while SEAC found that there was a risk of Article 3 being breached, it found that the evidence before the Secretary of State didn't suggest that Ms. Begum would be treated any differently from a woman who had not been deprived of her British nationality but was otherwise in the same situation. SEAC had proceeded on the basis that it was to approach the issue by adopting the principles of judicial review, not by looking at the merits of the Secretary of State's decision. The Court of Appeal, however, had proceeded on the basis that there should have been a full merits appeal in which SEAC should have stood in the shoes of the Secretary of State. Where did the Supreme Court stand on this issue? Again, the Supreme Court disagreed with the Court of Appeal and held that SEAC had taken the correct approach. It found that the power to deprive someone of their British citizenship is a discretionary power conferred by Parliament on the Secretary of State to be exercised in the public interest. It's open to the Secretary of State to produce policy to guide that exercise of power, and the adoption of such a policy does not affect the discretionary nature of the power or convert the policy into law. Accordingly, the Secretary of State may depart from that policy. However, a departure without good reason may be open to challenge on the basis that the decision maker failed to have regard to its own policy or misdirected itself as to the meaning of that policy. Now, the Supreme Court was of the view that the question of how the policy applies to particular facts, on the other hand, is a matter for the authority and subject only to the Wednesbury requirement of reasonableness. It was not, as the Court of Appeal had stated, for SEAC to exercise the discretion, the Secretary of State's discretion de novo. The role of the court is not supervisory. It is supervisory, not that of a primary decision maker. The question for the court wasn't whether Ms. Begum was at a real risk of treatment that would contravene Articles 2 or 3 of the ECHR. It was if those provisions had been applicable, but whether the Secretary of State had acted in compliance with his own policy. The Supreme Court held that the Secretary of State had to make a judgment as to the degree of risk based on the materials submitted to him by his officials and the security service. SEAC considered that the decision reached by the Secretary of State was not unreasonable. The Supreme Court held that SEAC's reasoning in relation to the issue wasn't defective. Accordingly, it allowed the Secretary of State's appeal against the decision to allow Ms. Begum's application for judicial review of SEAC's decision in relation to the extraterritorial human rights policy and dismissed Ms. Begum's application. So now the situation is that the appeal against the deprivation order remains stayed until Ms. Begum is in a position to effectively take part. And with that, I'll hand back to Mark.
Well, thank you much indeed, Farima. As I said, we do have time for a few questions. So if you have a question, please put it in the Q&A box and we will endeavour to reach that question. I wonder if I could perhaps ask Farima, just while we're waiting for questions to come in. You summarised in your last slide, the last point, that the Supreme Court did hold, perhaps not surprisingly, but the Secretary of State was required to follow his own policy, which he did in that case, which of course then begs the question, if he didn't follow his own policy, would the court refuse to intervene anyway on the grounds that this was a national security issue, which was beyond the scope of its authority? And I wonder if you have any comments about kind of a tension between the degree to which national security issues would trump everything else, or whether they're more restrictive in that respect. Any comments on that?
Yeah, that's an excellent question. It seems to be that it does trump everything else. The issue isn't just whether the court would act on such a challenge, it's how would an appellant raise such a challenge? The appellant and the Shamima Begum and her counsel aren't privy to the national security data or intelligence. So when matters go before SEAC, a special advocate is appointed, and the special advocate, so the Secretary of State's counsel, of course, see the national security data, and a special advocate is appointed to view the data, and they can advise, they could have advised Ms. Begum's counsel, but they're not actually allowed to tell them what the data says, what the information is. So while they could try to challenge the reasonableness, they're very limited on the grounds that they can challenge the reasonableness. They don't know what information is held. They don't know what the exact circumstance, what the exact basis is on which it's alleged that she is a threat to national security. So it is quite concerning that the Secretary of State can put forward the national security point, and that seems to put a stop on any other consideration. And it's also difficult to apply this to any future cases because we don't have any of the information behind the national security concerns. So it's difficult to say how another case might be decided, whether it would be the same or not, other than that, a blanket rule against the Secretary of State's discretion being questioned.
Okay, well, we haven't any questions from members of the audience so far. I just want to ask Stephen one brief point, if I may, on his slides, and then we'll see if anyone else wants to ask a question. If not, we'll close at that stage. But can I just clarify, Stephen, on the question of the circumstances in which somebody has no awareness of a potential right of appeal or review, and it was not communicated to them, but there was no chance, not just of a successful appeal or review being submitted, but no avenue to submit, make such a challenge. Would in those circumstances, the fact that any attempt to challenge review would have been was not open, in those circumstances, would a failure to communicate invalidate the decision taken by the, I presume, the Secretary of State or the entry clearance officer in this case?
Yeah, I think my view is that obviously the pointlessness or the pointlessness chapter really goes to materiality or utility. Obviously, if there's an error and it's not material, as in someone, even if someone says something, it's not going to make any difference, and that could be fatal. The only thing about materiality is it's quite a low threshold to get over, because the test for whether something's material is whether there's a real possibility that it might make a difference. So if someone can point to something, even if it's a relatively small thing, it may be enough to get over that hurdle. And certainly if you're talking about inevitability, inevitability is quite a high threshold for whoever is asserting that to cross. And again, if someone can point to something that, even if it's relatively small, it may be enough to get over the hurdle. But if there's absolutely nothing that can be done, then that would probably be fatal to the application.
Yeah, thank you, Stephen. Another question has come in from a member of the audience. This time back to the question Farima addressed, and that question is the Home Secretary's discretion absolute on matters of national security?
According to the Supreme Court in the Begum case, it is essentially absolute. The Supreme Court's view is that the Secretary of State is democratically accountable to Parliament and so to the public for these decisions, and so it's not for the judiciary to intervene in these matters. It sees it as an infringement on Parliament's ability to deal with these matters. Of course, they said that the discretion is subject to the requirements of reasonableness. But, as I mentioned, it's difficult to challenge something on the basis that it's unreasonable when you don't have the facts on which the decision was made. So effectively, the Supreme Court in this case was holding that the discretion is absolute. It said that the Secretary of State is considering a wide range of information that's been provided to him, and is in a much better position to exercise that discretion based on the information available than a judge could be. And that's quite concerning, in my opinion, because it limits the judiciary's ability to hold accountable the Secretary of State, and really to effectively consider whether decisions are reasonable or not.
Okay, well, thank you, Farima. Well, we don't have any more questions, so I think I will just draw our proceedings almost to an end, thanking Farima and Stephen, thanking all of you who have watched this webinar today. Can I just, though, before you go, just draw to attention our next webinar, which is on the 8th of April, and the theme of that will be employment matters. David Logan will be speaking on post-COVID economic realities for employers, and Peter Grant Hutchison will speak on TUPE, the Quiet Revolution from 1981 to 2021, and John Kiddy will be speaking on the recent Royal Mencap Society Supreme Court judgment. Again, another very interesting, important subject. We hope some of you may join us then, and look at our YouTube site, our website, for more information about future webinars and, of course, for the slides and presentations today. Thank you much indeed for watching us this afternoon. Goodbye.
Thank you.